approach the podium and state your name for the record. You may begin when you're ready.
Mr. Chief Justice, and may it please the court, my name is Arthur Cooper, and I'm here to demonstrate that Hugh Boy's verbal abuse of Tin Wan does constitute bullying under California state law. My co-counsel, Janice Poon, will demonstrate that Hugh Boy's speech is not protected by the First Amendment. My co-counsel, Andie Romero, will demonstrate that Sequester School District should be held liable for the damages suffered to Tin Wan. And my final co-counsel, Edward Rickford, will rebut the respondent's arguments. According to section 48900, subsection 1 of the California Education Statute, bullying is defined as any severe or pervasive verbal or physical act or conduct, including communications made in writing or by means of an electronic act. Although Hugh Boy's individual actions are not severe, the totality of his actions, the teasing Tin Wan after school, the posting stereotypical and racist drawings, and using Facebook and cell phones to constantly embarrass Tin Wan is severe. To be pervasive is to be omnipresent, and Hugh Boy's conduct was certainly so.
Counsel, isn't it true that a lot of this conduct didn't take place on campus? How can it be pervasive if it doesn't happen on school grounds?
Your Honor, the conduct can be pervasive because it pervaded almost every aspect of Tin Wan's life, even though while it took place on school campus, it also took place off campus and through the internet. It even invaded his home. Hugh Boy's use of internet, cell phones, and drawings invaded Tin Wan's academic and social life. So through the cartoonish drawings, which were most likely posted inside the school, Hugh Boy and the subsequent cell phone messages, Hugh Boy's bullying pervaded Tin Wan's academic environment. Through the Facebook page, Hugh Boy's bullying invaded a primary social media site.
Do we have prior case law describing this kind of conduct on the internet as pervasive?
As the courts found in Kowalski, the substantial disruption caused by the off-campus conduct was pervasive enough to be considered bullying.
Counsel, don't we have another criteria here, and that is a reasonable student, a reasonable pupil, and that's defined as somebody who's, in essence, average. The word average is used in it. Is this an average reaction to teasing, even if continuous?
Your Honor, according to subsection 3 of the California statute, a reasonable pupil exercises average care, skill, and judgment for a pupil of his age. Tin Wan's actions may seem rash, but they are reasonable for a pupil of his age.
So you're saying pretty much anybody in that school that had been teased like this would have gone out and committed suicide?
No, but when a student is in middle school, we can expect them to have a lesser level of maturity, and when faced with such overwhelming bullying, as in this case, such overwhelming and relentless bullying, Tin Wan was forced to see that the only other option was suicide.
But we're not comparing him to people other than his age. I'm comparing him to other people his age. Is this the average pupil who would react in this way?
Yes, Your Honor. Given his special circumstances, although not every pupil at the school may have reacted in that certain way, given Tin Wan's specific circumstances or exceptional needs as from the statute, Tin Wan was susceptible to this bullying and had that reaction, therefore, as a reasonable pupil.
What are these exceptional needs?
Mainly the pressures placed on him by his family and by his culture, which focused primarily on, or majorly on, academic performance.
So if we have another student who maybe has a family that doesn't put a lot of academic pressure, would the standard change?
Your Honor, yes, the standard would change because, as in the statute, it is what is defined as a reasonable pupil is subject to change because of the phrase that the student has exceptional needs. needs, may or may not have exceptional needs. And in this case, those exceptional needs are the culture that Tin One has been raised in.
What in the record indicates that this conduct rises to the level of severe under the statute?
While each individual action may not be severe, just taking them piece by piece, it's the totality, all of the actions combined into one block that make it severe. The teasing Tim after school relentlessly without regard for his personal feelings, the posting the stereotypical and racist drawings, and the countless and relentless bullying done by Hugh Boy and his friends, and most of the school after the cell phone messages and Facebook page went viral, rise to the level of severity that is required by the statute. However, despite Tin Wan's expected lack of maturity, Tin Wan took the initiative in going to the school principal, Headley Thick, and explaining the situation and the detrimental effect that the bullying was having. However, after several unproductive conversations and with the continuation of the bullying, Tin Wan decided he had no other option other than suicide. Therefore, Hugh Boy's conduct, as required by subsection 1D of the California Education Statute, caused a reasonable pupil, Tin Wan, to experience a substantial interference with his ability to participate in or benefit from school services.
Isn't there something in the record indicating that he was already struggling with school?
While Tin Wan may have been already struggling in school in his math classes, I believe you're referring to, the bullying certainly didn't help his academic performance. It may have distracted him more, we don't know. But we can look to Tin Wan's, what Tin Wan said to the principal, in that the bullying was having a detrimental effect on his education and his academic performance.
Well, counsel, if we concede we don't know, it seems you're not carrying your burden of proof of establishing the cause for the harm. If we don't know what caused it, how can we say that the school district should be liable?
I'm sorry, can you rephrase your question?
Yeah, you said we don't know whether it made it worse or not. And if we don't know, then we can't say that the principal caused it.
That is true, however, the principal did not act, as my co-counsel will demonstrate, the principal did not act to his full ability to prevent the bullying from occurring or from continuing once he was made aware of it by Tin Wan's visits and conversations with him.
But if it didn't matter whether he did it or not, then it doesn't matter whether he did it or not, right?
What do you mean it didn't matter whether he
Well,
did it?
if we're saying that we can't establish that his not acting caused it, he might have done it anyway, then there's no connection between the inaction and the end result, correct?
That is true, however, the principal had a right and a duty to prevent the bullying, and by not doing that, he failed to perform his duties that he was obliged to do, to perform, and therefore makes the school district liable for his inaction, even if regardless of his action or inaction, the events would have taken place.
Counsel, you mentioned earlier that it was not necessarily one act, but the totality of circumstances. But why should all of the conduct be in the record be attributed to Hugh Boy? Isn't it true that it was other students that in fact were calling him names, that it was not in fact Hugh Boy that created the Facebook page? Why should that conduct be attributed to Hugh Boy to establish bullying against him?
Because, Your Honor, Hugh Boy was the instigator of each of these, of the majority of the conduct against Tin Wan. Hugh Boy asked the friend to create a Facebook page. Hugh Boy sent the text messages around the school, which went viral and affected a large portion of the school population. Hugh Boy posted the drawing, which he drew himself, and Hugh Boy teased Tin Wan after school. The majority of the actions and the main severe actions that were relentless and would not stop and focused primarily on Tin Wan were caused by were performed by Hugh Boy.
So should we disregard the other actions that were not in fact initiated by Hugh Boy?
No, but due to their lacking severity and Tin Wan's main claim that it was Hugh Boy who caused his psychological trauma and his detrimental effect on his ability to participate in school and his academic performance, we must focus mainly on Hugh Boy in this case. And on the basis of the evidence provided, I urge the court to overturn the appellate court's decision and to determine that Hugh Boy's conduct does constitute bullying. Thank you, and now my co-counsel Janice Poon will discuss the First Amendment issue.
Mr. Chief Justice, and may it please the court, my name is Janice Poon.
Please approach the podium.
Sorry.
Thank you.
Mr. Chief Justice, and may it please the court, my name is Janice Poon, and I'm here to urge the court to find that Hugh Boy's hate speech is not protected by the First Amendment and thus should have been stopped by the school. The First Amendment provisions for basic civil liberties such as free speech, but this does not transfer into an absolute guarantee without any limitations. The Supreme Court has established certain restrictions on free speech in order to protect the rights of others, such as in defamation or harassment. And furthermore, the court has held in Hazelwood that the First Amendment rights of students are not automatically coextensive with the rights of adults in public schools and allows censorship of speech in order to protect the basic educational mission within the school.
Counsel, you mentioned that this is hate speech, and I don't see how the phrase "King of the Einsteins" can amount to hate speech. Could you elaborate on that a little further?
Well, Your Honor, Hugh Boy's speech was very pervasive and, as my co-counsel demonstrated, qualifies as bullying. And within the school environment, when you bully someone, that speech is very hurtful and infringes on the rights of the victim and destroys the school environment.
But hurtful speech and disruptful speech doesn't necessarily qualify as hate speech, does it?
Well, Your Honor, we have to look at the circumstances provided, and in our case, Hugh Boy's speech, as directed to Tin Wan, led him to even attempted suicide. So the effects of his speech were very severe.
Well, the effects of speech don't mean that the speech is qualified as hate speech, does it?
Well, not necessarily.
So what is hate speech in your own words?
Hate speech is a type of bullying that is very severe and causes a reasonable pupil to have a detrimental effect on a reasonable pupil.
Well, wouldn't that mean that anytime someone calls somebody dumb or stupid, that it's hate speech? That seems like a very low threshold to establish hate speech, which is not protected by the First Amendment, whereas calling someone dumb or stupid probably would be protected by the First Amendment. Where do we draw the line as a court?
Well, Your Honor, when we look at the Tinker case has established the standard as long as the speech materially and substantially disrupts the school environment, then the school has the right to stop that speech and censor it. And so in our case, Hugh Boy's speech was not protected because of its effects, and the school absolutely had the right to stop it. The first incident of bullying occurred at a site not directly on school campus, but at a tutoring site near the school. Yet the tutoring was considered a school-sanctioned project because, one, Mr. Dew, the head teacher of the tutoring project, was granted an Outstanding Teacher of the Month award from the school, and two, Principal Thick was publicly associated with heading the project since he was publicly thanked in the local paper, which shows an imprimatur of White's Junior High.
Counsel, where do we draw the line, though? Suppose it was a Little League or Pony League baseball game, and every time Mr. Tin came up to bat, they yelled, "Batter, you stink, you stink." Every time he came to bat, every game, and all of it was students from the school. Does that fall under the statute? Is the principal supposed to take some action?
Well, Your Honor, when we look to the Kowalski case, the courts held that as long as speech, even if made off campus, has a sufficient nexus to on campus and creates a detrimental effect and disrupts the school environment, then the speech can be censored.
What is the disruption? What was the detrimental effect?
In our case?
Yes.
Well, when we look at our case, Hugh Boy's speech, when he bullied Tin Wan, he rallied up his friends to gang up on Tin-Wan and created such a commotion that even the principal had to step in. Like, even the principal found out about what happened, which shows the amount of disruption that occurred in the school. And it even pushed Tin-Wan to missing school. And as the courts held in Kowalski, Cheyenne missing school proved to be enough of a substantial disruption for the speech to be censored. And thus, Hugh Boyd, like JS of the Snyder versus Blue Mountain case, he created a debasing Facebook page to attack another individual from off campus. Though our facts do not clarify whether Boyd or his cohorts created the page on or off campus. And if it was on campus, Boyd's speech certainly would be subject to the censorship of school officials. But even if it was off campus, we can see in the Snyder versus Blue Mountain case that the court empowered the school to punish JS, affirming that her protected free speech rights ended when her actions threatened to cause a substantial disruption at school.
Counsel, the exact same Court of Appeals in Leishop, on almost identical facts, went the other way. So why shouldn't we follow Leishop instead of Snyder?
Well, Your Honor, when we look at Leishop, the court found that officials punished Justin for the content of the speech, not for the substantial effect it created on campus, as the courts held that it didn't create a substantial effect on campus. But when we look at our case, it created more of a substantial disruption, just like the Snyder case. And because it caused such a disruption on campus, his harassment damaged the overall school environment and damaged the school's basic educational mission, which which makes it the duty of the school to censor his speech. And even in Kowalski versus Berkeley County, the courts held that the Constitution is not written to hinder school administrators' efforts to address hate speech and cyberbullying issues. The circumstances closely parallel our facts, as Kowalski also created a targeted attack on a classmate online. And both bullying pages and both creators of the bullying pages reasonably expected for their off-campus speech to reach the school campus, even though it originated from outside school gates.
Counsel, I know a few folks around the age of the plaintiff in this case, and it is my observation that many, if not all folks of this age group have a Facebook, they have an email account, they have cell phones to text message. Aren't we, if we follow your logic, doesn't that mean that one principal has to police the online activity of potentially hundreds or thousands of students? That sounds like a lot of work to ask of our already burdened school administrators.
Well, Your Honor, the principal doesn't have the duty to police the internet, but if the speech effect creates such a substantial disruption on campus, then it is the duty of the principal to step in, to censor, to stop the disruption so that students can have a safe learning environment. So as long as there's a sufficient nexus between off-campus speech and effects on campus, then the school would have the duty to censor the speech. And therefore, I urge the court to find it the school district's duty to restrain Hugh Boyd's speech. And now my co-counsel, Andie Romero, will discuss the issue of negligence.
Mr. Chief Justice, and may it please the court, my name is Andriana Romero, and I'm going to demonstrate that Sequester School District should be held financially liable for the damages that Tin-Wan incurred. I will demonstrate first that there is a duty that Mr. Thick owed to Tin-Wan, and secondly, that there's a causal linkage between the principal's negligence and his emotional distress. As my co-counsel have demonstrated, the California Education Code provides that each education agency have not only a policy that prohibits bullying, but a program that investigates violations against these standards. The intentions of these standards is not were not established in hopes that personnel and pupils would willingly comply, but clearly dictates that California school districts have a duty to efficiently prevent, investigate, and actively prevent damages to its students, whom they are liable for protecting.
Well, what about, in this case, it appears that the principal was summoned twice to speak with the plaintiff. Now, based on what you just said, the principal has a duty to investigate. What if we can conclude that the principal did investigate and he concluded that it was not a substantial disruption? He fulfilled his duty and it should end there.
Your Honor, actually, the facts are unclear. They're ambiguous whether he was summoned or Tin Wan was summoned. Either way, if Mr. Thick had said he concluded that it was not a substantial disruption, he did not efficiently prevent Tin Wan from bullying. He only investigated, but because Hugh Boy's free speech was not protected, his duty was much. He was obliged to go much farther with his duty that was established by the policy and by the foreseeability of the circumstances surrounding this case. Your Honor.
Counsel, you're saying then, if I understand you correctly, that the duty arises from the statute. Is that correct?
Yes, Your Honor.
But the statute also provides a remedy, and that is that the offender be punished, and that would be Mr. Boy. There's nothing in there about the victim getting money, and the Court of Appeals has said that's for the legislature. Should we be rewriting this law, or should that be left to the legislature?
Your Honor, the case before us allows us to, gives us the opportunity to award necessary damages to a student that was reaching out to a principal, reaching out for help. Your Honor, it's established by California law that school district personnel are supposed to be the guardians, that they are supposed to prevent damages to their students, and he failed by that statute.
Counsel, we are very sympathetic towards the plaintiff here. He suffered a tremendous harm. However, as the judicial branch, we don't necessarily feel that it's our appropriate role to award money damages unless and until the legislature gives us explicit permission to do exactly that, which I believe is what my colleague was aiming for. Is there a case or a statute that gives us the power to award money damages if we do find liability?
Your Honor, the liability in this case is emotional distress, which is very similar to what happened in Dillon, where they found it was reasonably foreseeable that the negligent driver would foresee that the child and his or her mother would be in that proximity, would be in that very zone of danger. If we apply this to our case, the court did allow award money or awards to that negligence to emotional distress or trauma in that case. Is very similar to our case before us. True,
If you were suing Mr. Boy, because Mr. Boy is the guy who did something wrong, just like the driver of the car. The principal here might not have followed the school's policy, but his duty is to the school, correct?
Your Honor, we cannot sue a student against a student, but it's a duty of an official. Your Honor, the official is, Your Honor, student to student is not in the scope of duty for us, for the judicial branch to have that jurisdiction. But for a principal to neglect his duty for such a pressing issue, established by the statute, by the foreseeability, and all the factors that point to reasonableness that Mr. Tin Wan would react in such a way.
Counsel, isn't it true that the principal didn't have actual knowledge of a lot of this conduct, that he was never made aware of the Facebook page and the cell phone pictures? I didn't see anything in the record that indicated he was aware of those incidents.
Your Honor, even though those facts that you mentioned are ambiguous, if we do look at the facts that he was knowledgeable about, that he met with Tin Wan twice, that he was knowledgeable about his Tin Wan's emotion, pressure from his parents already, and that he had been failing his grades, and he was even knowledgeable about the ongoing bullying that that Tin Wan was going through from the first and the second meetings. That it's reasonable to say a reasonable person in that place, in Mr. Thick's place, would have that duty to address that issue.
But those meetings that he had with him on took place before the other conduct that I referred to, correct?
Your Honor, it's ambiguous whether it happened before or after. Even if it did happen afterwards, the circumstances in this case still would allow a reasonable person to suspect that, or deduce that anything more would cause emotional distress to Tin Wan if not addressed at that very moment.
What if we're concerned about very tight budgets in schools these days, and if we find for your client, it could impose crushing liability on lots of other schools, not just like this one, but we could potentially throw open the doors to a whole new realm of financial issues on schools that has never been contemplated before.
Your Honor, as you to address your question that you posed before me, Your Honor, we are not flooding the gates of litigation. This is a pressing issue that should be addressed, even if it requires award damages. Your Honor, there's no way we can, in either way that we can remedy the emotional distress that he incurred. There's no way that we could fix Tin Wan or just, that's why we are awarding monetary awards.
But counsel, it's my understanding from reading the paper and talking to people that bullying is pervasive in our schools. And that's why the legislature passed the law, because there aren't isolated instances. So, why wouldn't there be a flood of litigation if suddenly we started holding school districts liable for every episode of bullying?
Can you please repeat?
Yes, it seems that there is a lot of bullying going on. There's a law. They made a law. And if every one of those things became an $80,000 case for a school district, isn't it going to put them out of business?
Your Honor, it's questionable whether to say that each case, like ours, would award $80,000, but if they are asking for monetary awards, it is our duty as the judicial branch to check on the legislative branch to follow through with what their policies. And if our judicial branch were to follow through with what the legislation has posed before us, which was to follow through with their policy, having an investigative and means to efficiently prevent damages to students, then that is our duty, and that is where we can step in. Your Honor, regarding foreseeability, as I have mentioned, foreseeability and the California statute establish the duty. And causation, Your Honor, the factors of this case pose that it's reasonable to suspect that any further neglect to a student who's reaching out for help would cause him to not necessarily commit suicide, but still constitute emotional distress, which is liable for is a tort, Your Honor.
One last question. If this man had been suspended, this boy had been suspended, do you really think he's going to let up in bullying, or might it not get even worse?
So are you suggesting that we should have something in place to punish Hugh Boy, to prevent him from bullying?
Well, isn't that what the statute provides, that he'd be suspended or otherwise punished?
Yes, Your Honor, but the question before us is not whether we're supposed to decide the fate of Hugh Boy, but to address the negligence of Mr. Thick.
But what could Mr. Thick have done if he followed the statute? He's suspended. There's nothing else in the statute that he's allowed to do.
As my co-counsel have demonstrated, Hugh Boy's speech was not protected. He could have, Your Honor.
You can have a minute to finish your thought.
Okay, Your Honor, he could have suspended him, but he did not do that. He neglected his duty and allowed him to find no other option but to commit suicide.
Counsel for the respondent, please approach the podium and state your name for the record.
Good evening, Your Honor. May it please the court. his friends does not constitute bullying under the California Education Code. First off, I would like to refer to the definition of bullying, which requires a severe or pervasive physical or verbal act or conduct. Taking this fact situation into account in this case, the relatively average name calling that Tin Juan dealt with was neither severe nor pervasive. There are several examples of this behavior in the fact situation, which help us establish the unfounded severity. For instance, on page 2, we see such vocabulary as nothing more than taunting and teasing. This means that the action of the pupil resembles something more along the lines of everyday teasing rather than bullying, which is something we all have to go through in life.
So, under that logic, does that mean that we as a court can tell the public that there is an acceptable amount of teasing that everyone's just going to have to deal with in public schools? And if you go to a public school, you have to expect to be teased before, and there has to be an extreme amount of it before a principal or a court is going to intervene?
Well, rather than the acceptable amount, Your Honor, it would be more pertaining to the lines of both severity and the reasonableness of the student, as we are as such is questionable in this case. With one such that the fact is the stereotyping in this case against Tin Juan is the fact that he is rather good at math, which even in on line 10 and 11 of the fact situation, you can see that Hugh Boyd is quoted as stating that he believes so. And we can determine that even in believing he was, even if we believe that he didn't know about Tin Juan's struggling in school, that the stereotyping in this case is rather less severe than we can find in many other cases.
So are you suggesting that certain types of stereotyping are okay?
Rather less severe than okay. Especially, as I said earlier, the fact that Hugh Boyd indeed did believe that he was smart in this case, rather than pertaining to the actual stereotype, it was more pertaining towards Tin Juan.
Okay, counsel, let's say for the moment that we say it wasn't severe. So what? Seems to me it's certainly pervasive. And how can you say it is not?
Well, Your Honor, even if we concede that the behavior was pervasive, we still have to take into account of the reasonableness of Tin Juan himself, which, considering his reaction to such lenient teasing, we could find that an answer with such as attempting suicide is far beyond an average response. If, as the opposing counsel has stated earlier, we have to take into account his background, his pressure that he received, then does this not indeed provide another source of his mental deterioration rather than Hugh Boyd himself?
How do we harmonize that with the eggshell plaintiff rule, which tells us that we have to take a plaintiff in whatever circumstance they come to us? Some people are going to have very fragile egos, and some people are going to be a little more thick-skinned. And so in this plaintiff's case, it sounds like he was already a sensitive young man. Shouldn't we give him the benefit of the doubt on that?
Well, Your Honor, in this case, Tin Juan had many decisions that he could have gone with, and taking into account that his grades were already dropping very, very, and to the point where he had to go to tutoring, and we are not given any indication that they are improving, rather that he is just attending the tutoring. We can see that perhaps in this case, he was already going in the path of mental deterioration long before Hugh Boyd came along.
Counsel, you said there's other things he could have done. You suggested he punched Mr. Boyd out. I mean, what other things could he have done to deal with this than go to the principal?
Well, Your Honor, he also had the option of telling many of those around him who would have helped, especially those, the reactions of his parents. He didn't tell his friends, and we could see that suicide is rather a rather outrageous response for teasing rather than telling someone that cares about you.
Is it really appropriate for the court to blame the victim for reacting strongly to a difficult situation?
Well, we should not blame, with all due respect to Tin Juan, Your Honor, we should not blame him or condemn him for his actions, but to accuse Hugh Boy of bullying would rather be unfair to him in the fact we would be setting him on a potentially harmful path that he might not recover from. We aren't given any indication that he has done anything wrong before to any other students, and as we stated earlier, this type of teasing was less severe than it could have been.
Well, go ahead.
What is your authority for, if you're suggesting that we should consider what Hugh Boy has done before the incidents with Tin Juan, do you have authority to support that?
Could you repeat the question?
You said Hugh Boy has, we have nothing in the record to indicate he's ever done anything prior to this. Why should that be a factor that we consider?
Well, Your Honor, it's rather, I suppose, adding to Hugh Boy's, rather detracting from Hugh Boy's status as a bully and his friends of being gang. We are not given the fact that for this that they were bad kids. We are not stating that he was failing at math as Tin Juan was, with all due respect.
Counsel, let's consider an alternative hypothetical. Rather than using words to emotionally harm the plaintiff, what if we used touching to physically harm the plaintiff? So instead of punching the plaintiff, the defendant sent text messages to all of his friends at school, and he created a Facebook page saying, when you see Tin Juan, you gotta flick him behind the ear in his earlobe. Sure, it's not enough to really harm him, but it's enough that if you had 300 people walking up behind you flicking you in the ear every day, that might constitute physical bullying. Isn't the aggregate of encouraging a lot of peers to all do one small thing enough in this case?
Well, Your Honor, still in that case, we would have to take into account why when Tin Juan attempt to tell anyone, especially his parents or friends, about the severe ear flicking.
But counsel, he told the person that is supposed to act under the statute. We're not here going after his parents. We're here with somebody going after the school district. And that is who we went to and who the law set up to protect him from these things. What does going to his parents have to do with it?
Well, his parents rather did, once his parents found out after his attempted and failed suicide, they did take immediate action, which, while misdirected towards the school district itself, rather than taking proper precautions what they had done themselves, they did respond rather quickly, which I would suppose would be better to Juan losing his life.
What's the point of the statute then? If you're supposed to go to your parents instead of to the principal, are we just supposed to ignore the statute?
Well, we were given indication that in the fact situation that Juan did have meetings with Principal Thick. We are not told what happened in those meetings. So we cannot tell that how attentive Tin Juan was towards telling people about what had happened. Your Honor, I hope that you find that Tin Juan Your Honor, I am hoping that you find that the actions of Hugh Boy and his friends do not constitute bullying under the California Education Code.
Good evening, Your Honor. May it please the court, my name is Paige Lloyd. Today I'll be arguing that Hugh Boy and his friend's speech is protected by the First Amendment. The speech by Hugh Boy and his friends is not subject to sanction by the school because it did not interfere with the school's educational mission. First, Hugh Boy's actions of putting the posters that were supposed to represent Tin Juan on the school wall there were at the most 10 posters. There was no indication that students even got to see the posters before principal, that immediately had them taken down. He took them down himself.
Well, can't we infer from the record that someone would have had to have seen the poster and informed the principal? I don't think there's anything in the record that suggests he took it down the minute it was put up.
Well, it says I assume that it says in there that the principal, when he seen the posters, he took them down. He didn't let them dolly there and just walk away from them. He had them. He took them down himself. And I believe that we can say when students are walking in the hallways, they're really not paying attention to the posters that are hanging on the wall. They're talking to their friends, getting to their classes. You know, when students are coming out of their class periods, they want to talk to their friends and socialize. They're not paying attention to things that hang on the wall.
Wouldn't it be enough to say that there was one poster, even for half a day, regardless of the number of posters that were up? If one poster was there for one day, wouldn't that be enough?
Well, maybe, Your Honor, but in this case, there's no evidence stating that the posters caused a substantial disruption with the school students. There was no evidence that supported that.
It appears to have caused a substantial disruption in the plaintiff's instruction. He went so far as to attempt suicide. That sounds like a very substantial interruption in his education.
Well, yes, he met with the principal about his actions, and he had 2 brief meetings, but there was also nothing said. He didn't let the principal Thicke know how much of the teasing was bothering him. There was no evidence that stated how much Principal Thicke really knew about the teasing. And obviously it was enough for Principal Thicke to believe that it wasn't a substantial disruption. And I assume had it would be if Tinwan realized that Principal Thicke hadn't done nothing and he was still getting constantly picked on and this was weighing on him so hard, he could have gone himself, he could have taken it in himself to gone to someone else, gone to a counselor. He should have chose to push harder if it bothered him so much to attempt suicide. He could have gone to his parents, gone to maybe a close friend's parents, an outside resource, if he's saying that the principal did nothing.
Well, that can be quite troublesome because we have educators and school administrators who are charged with the duty to maintain a stable and supportive school environment. And by your suggestion, a plaintiff would have to go to a counselor or someone else's parent. That sounds very troublesome for a court to hold that school administrators get a pass because students have to take an extra step and contact outside parents or something like that.
Well, yes, but how is Principal Thicke to know if Tinwan wasn't giving him more information about the situation? He didn't realize how high the teasing was in Tinwan because he didn't take it upon himself to let him know. He may have been shy, but if you feel that need to that pressure of someone teasing on you, picking on you, it's up to you to go and take that chance and try to find somebody who will actually listen to you.
Counsel, if I may, I'd like to get back to the speech issue. Do you really seriously contend that this type of speech in this type of environment is protected by the First Amendment?
Well, Hugh Boy's speech, other than the posters, were mostly off of school grounds. Hugh Boy created a website, created a website and sent a text message, but these things were all sent off school grounds. With the text message sent to the school, cell phones are a disruption to a school period. Students have them everywhere. If Hugh Boy hadn't even not sent that text message or webpage, students would have still been on their phone, whether they were texting someone else or playing Angry Birds. There's no evidence stating that students were disrupting class and flipping open their phones to look at the text messages that Hugh Boy sent, or getting on the website and using school appliances to get on the website to look at the webpage that was created. All of these things were created off of school grounds.
Counsel, didn't most of the students then start referring to Tinwan as King of the Einsteins directly as a result of the text message?
Well, yes, but not the whole student body.
But that happened on school grounds, correct?
Well, yes, but Tin-Wan, he didn't go forward also to tell the principal about what was going on with these words. He didn't, there's no indication that principal think heard the name, I don't believe. And if the name bothered him so he once again could have gone to somebody else and told them. And with the webpage, Your Honor, if you look at Layshock versus Herman School District, where also a student created an administrated website of his principal, the ruling in this case is that a student had the First Amendment right. The court concluded this simply because there was no evidence that the website created a substantial amount of disruption in the school's education mission. There were no proof that students were getting on the website during school hours, on school
Counsel,
property.
isn't this a whole lot more like Kowalski, where a single individual student was being targeted and picked on severely and obscenely in that particular case? There we had dealing with sexual accusations. Here we're dealing with racial stereotyping. You know, where's the difference between those two?
Your Honor, in Kowalski, there were two different major types of speech. With Kowalski, there was lots of profanity and sexual contact. So can we really compare these two cases, which a high school student, someone in an older level, grade level, who's more able to withstand that mean-spirited speech because they've gone through it their middle school life, to a student who also, they were being accused of having STDs. Can we compare that to a middle school student being called smart?
Well, they weren't truly and genuinely calling the student smart, were they? They were using sarcasm, where you say one thing and you mean the opposite.
Well, yeah, but that's, with Kowalski, it's just so major, it's such the major difference of the type of speech that the school was able to crack down on for the STDs and calling someone who has herpes and just so much just vile language towards one student.
I'm troubled to consider the fact that we would potentially be opening the door to more students saying more troublesome and disruptive things along racial lines. And that concerns me quite a bit. Where are we supposed to draw the line for what types of speech are protected and what types of speech are not protected?
Can you rephrase it, Your Honor, please?
Counsel, I'm concerned that while you might be comparing the facts of that case to the case at hand based on false allegations of sexual conduct to racial stereotyping, I think that we should and can treat them equally, and when the speech rises to a severe level, as it may in this case, we should give school administrators the power to intervene.
Yes, Your Honor, but in this case, I think Tin-Wan should have decided where to draw the line of how much he could withstand when he realized how far it was pushing him. With Kowalski, the girl, she went directly to her parents. Her parents came up to the school. Their parents were involved. She pushed she pushed with what was going on with her. Tin-Wan didn't go to anyone. He didn't push the subject further.
Well, every student is going to react differently. Some students will be more outspoken and some may be more embarrassed or perhaps more shy. Shouldn't we really put the duty on the school and the school administrator to thoroughly and effectively investigate every substantial claim, regardless of how well the student does or doesn't handle the problem?
Well, yes, when it intervenes with the school, but in this case, no one indicated that anything was a substantial disruption for the school to intervene.
But counsel, let's go back to Kowalski again. The principal did intervene, the school did intervene, and the court said that's good, and there wasn't even a bullying statute. Here we do have a bullying statute telling the principal to intervene, telling the principal to do something, and he didn't. Now, why is not this speech equally impermissible to the speech over there when we have a statute prohibiting that type of speech?
Well, I think you also, with Kowalski, have to take age in order, because when you have someone who's a high school student, they're more able to withstand this type of vulgar language than if you called a high school student smart. they would be able to brush it off than a middle school student, yeah. And with Tin Juan, can you rephrase some of the question?
Yeah, we've got a statute that says this type of thing is wrong and should be punished. There didn't even have that in Kowalski, and yet the punishment was upheld. So why is the speech here protected by the First Amendment if it wasn't protected in Kowalski? Doesn't the statute give some sort of strength to the argument it's not protected speech?
Your Honor, yeah, I believe that applies with that it might apply with age as well, because it had been Tin Juan who was being called all these vulgar names in school on the website, then yes, the school should have stepped in. This is a younger child who shouldn't have to hear those things, but with a high school student, it's different. Excuse me, Your Honor. But also with Kowalski, there was evidence stating that the girl who created the website intended to direct it to the students at their school. She knew that the people who would come to the website would be there, who would all go to the school, were directed at her. For the one who was being said had STDs. Also, Your Honor, with Hugh Boyd's actions of going off school grounds to the tutoring site, that site was strictly volunteer basis. Everyone who was there, it wasn't a school required class. Those students were not required to go to the tutoring session.
I'm not sure that helps you, counselor, because if some off-campus conduct creates a disruption that comes onto campus, I believe the statute gives school administrators opportunities to intervene.
Well, it was still on public grounds, and Hugh Boyd and his friends are part of the public. They had the right to use their First Amendment right. It was off school grounds. They weren't on there. It wasn't, the school can't go in when it wasn't on school grounds. They didn't use anything from the school, they didn't step anywhere near the school. It was strictly off school grounds. It was a volunteer basis. In Hazelwood versus Colmeyer, there was a similar issue, and some of the facts were students published a school newspaper where some articles contained things that seemed inappropriate, and the principal in that case had the right to crack down on these kids because of the facts. The article was created during school hours on school grounds. It was a required class. These students were required to take this class. They had no other choice. The teacher who was teaching the class were being paid to do it, other than Mr. Duke, who was strictly a volunteer teacher. He wasn't paid for any of it, like a school-sponsored activity is. So you really can't say that like this volunteer basis was a school-sponsored activity. Your Honor, I ask that you see that Hugh Boyd and his friend's speech is protected by the First Amendment.
The argument that the sequestered school district should not be held financially liable for the damages that the trial court found were a result of Hugh Boyd and his friends teasing of Tin Juan, which the principal had launched. Your Honor, Tin Juan was not a reasonable student. He was an extra sensitive middle school kid. The fact pattern even stated that he had pressure from his family and his ethnic community. So he had a lot of pressure on him already. And how could the principal know about that
That's his personal life. The principals do not know everything about you. All he knew was that teasing was going on. Now, as you mentioned with my co-counsel about the HL plaintiff, in Stolson it also mentions a companion rule, which I think we should go by. It states, that case cites Abernathy, where he had a back injury and he got hurt. But the companion rule was followed, which I think this court should follow as well, because the damage that he had might have already happened, regardless of the accident. So we don't know if Tin Wan was already thinking about attempting suicide. He had a lot of pressure, and we can't draw the line to say, oh, well, this much pressure was from his family and community, and this much pressure was from the teasing. Say something else happened in his family, and maybe he would have attempted suicide then, and without the teasing. So, because we do not know where to draw the line, it is Tin Wan's obligation to, and there's no way to. Therefore, we should use the companion rule in this case.
Counsel, I think the statute might cancel out that argument for you, because it talks about a person with his or her exceptional needs, and the fact that there is all of this parental pressure, peer pressure, and other things like that, seem to me might be creating a exceptional need that we have to take into account when we determine whether he was a reasonable principal.
Well, the statute from the school, how is the school supposed to know that he has exceptional needs? The school does not know what pressures people are already under unless he brings them up already. It says that he met with the principal for the teasing and his truancies. It does not say that he went to counseling because of his family pressures and everything. Most students can handle that type of pressure, but Tin Wan, you can't draw the line. And it states if you cannot draw the line, it's upon Tin Wan, it's his duty to draw the line, and he can't. Therefore, we should not.
But counsel, are you saying we should just ignore the second half of subdivision 3, talking about exceptional needs? Should we also ignore age? Should we also ignore the other things in here that we judge the reasonable pupil by?
No, we should not, but I believe that it does meet the standards for the companion rule. And it does say that Tin Wan met with the principal, so the principal had no foreseeability in this. If he foresaw that Tin Wan was going to attempt suicide, he would have stepped in. Because he did not know about the prior stresses and everything, he didn't know. He saw no red flags. So,
Counselor, I'm concerned that if we follow your reasoning, that allows negligent or maybe grossly negligent school administrators to bury their head in the sand and ignore a few small facts and not follow through on their duty to investigate. If a student approaches a school administrator with some concerns, and we also have objective facts relating to his truancy problem, wouldn't a reasonable administrator tie all of those things together and have to follow through and see what the home situation is, what the extent of the bullying is, and actually the statute not only empowers them to do that, but perhaps places that duty on them too.
well, yes, it is his duty to follow through, but as we know, he did take the posters down and he did meet with Tin Wan. So if he did do those things, then he might have not foresaw that. And we don't know that the principal knew about the off-campus things. Like he might have not known about the Facebook page. He might not have known about the text messages, which made it all the more pervasive, but he might not have known. It does not state that. So I don't think we can infer that he knew about everything.
But shouldn't he have taken the trouble to inform himself if he didn't know? Shouldn't he have taken more steps, done more investigation than what he did? Taking a few posters down is some effort, but as a bench, we're concerned that it wasn't enough effort.
Well, it it just tells him to follow up on it, and he did. He followed. He had multiple meetings with Tin Wan, and he did do what he saw. He took care of the situation then, and that should be enough. If Tin Wan really thought that it was bad enough, then he might have gone to, but he could not have foreseen it. Because if he would have, then yes, it is his duty to go forward with it. But I argue that he did not see it.
Counsel, you're saying we don't know. We're not here to decide the facts. The trial court already did that and said that the principal had adequate knowledge of the action of Hugh Boyce and his gang towards Tin Wan. That's a given. He had that enough knowledge. So, we're not going to go there. I mean, what else do you have?
Okay, well, as in Long Island Railroad Company against Paulsgraf, the package, the main carrying exploded and Mrs. Paulsgraf got hurt. And Mrs. Paulsgraf did not get money because the railroad company could not have foreseen it. The railroad company was not the wrongdoer. Why should we punish the principal if he is not the wrongdoer?
Because the wrong that was done here was not intervening in time. The wrong that was done would be arguably more than in the Paulsgraf situation. No train company is going to check every package with every passenger, but if a student brings a concern to a principal, shouldn't we expect them to follow through a little more than the principal did in this case?
Well, the statute just says that he needs to investigate and he needs to do something, and he did do something. So he technically did follow through with the statute, and he did do his job.
Counsel, you mentioned several times that he could not have foreseen how this would play out with the suicide attempt and whatnot. But doesn't that get more into the degree of Tin Wan's damages? Isn't the foreseeability really the fact that it would cause distress in the first place, that what was going on would be invasive to Tin Wan, and the fact that he ultimately caused suicide, that's just the degree of damages that he suffered. But wasn't it foreseeable that he would suffer damage in the first place from the bullying?
He might have been damaged from it, but we don't know to what extent. Of course his feelings would get hurt, but if the principal would have known that it would have hurt him so badly to attempt suicide, he would have done more.
But isn't that the eggshell theory, that you take the victim as a final?
Only if the companion rule does not apply. And Tin Wan might have already been thinking about attempting suicide, and something else might have come up to cause him to attempt suicide. And it is his burden to prove that it wasn't going to. So since he did not draw the line, and we can't have numbers to say, okay, well, this must cause this much, and this must cause this much, we cannot blame the school district. Thank you, Your Honor. My time is up.
Do we have rebuttal from the appellant?
Yes, Your Honor. Mr. Chief Justice, may it please the court, my name is Edward Bickford, and I'm here to show the shortcomings of the respondent's argument that were particularly notable in their interpretations of the anti-bullying statute, Kowalski, and Paulsgraf. The respondent argued that Tin Wan was not bullied, but the evidence shows otherwise. According to the anti-bullying statute, bullying is anything that results in severe physical or mental harm. True, the physical harm that Tin Wan suffered was largely self-inflicted, but the emotional harm he suffered was undoubtedly inflicted by Hugh Boy. Hugh Boy regularly waited outside of his tutoring center simply to mock him and ridicule him. But Hugh Boy did not stop here. He also encouraged his friends to join in and called Tin Wan the king of the Einsteins whenever they saw him. He had one of his friends make a Facebook page claiming that Tin Wan felt that he was a master of all mathematical concepts. Just because much of this speech took place through an electronic medium does not make it any less subject to the anti-bullying statute, since the anti-bullying statute clearly states that any speech, even communications made by an electronic means, is still considered bullying.
The First Amendment protects speech. So we've got a statute here that seems to be butting right up against the First Amendment there.
Your Honor, the courts have already found that not all speech is to be protected at school. In the Hazelwood case, the courts found that speech was not to be protected at school in certain circumstances. In the Layshaw case, the courts found that certain speech was not to be protected in certain circumstances. Seeing as how the courts have already established that speech can be censored on school grounds, it seems that it is more than reasonable to censor this speech as well. Furthermore, Section D of the anti-bullying statute stipulates that anything that interferes with a pupil's ability to participate in or benefit from school service is to be considered bullying. Hugh Boy's actions certainly meet this criteria. Waiting outside of a tutoring center simply to ridicule another student can be depicted as little else. Such speech needs to be censored. A student should not expect that simply because they go to public school, they will have to be subject to bullying.
Do you contend that waiting outside of the center is either severe or pervasive?
Your Honor, waiting outside the tutoring center interfered with his ability to benefit from the services being provided by the school, being provided by the teacher, because there was so much shame affiliated with going to this simple activity that Tin Wan felt he could no longer go to the tutoring without being ridiculed, without being mocked.
But counsel, that doesn't interfere with a school activity. By definition and description, that's interfering with something away from the school, not conducted by the school, known to the school, but it's not a school activity. The guy wasn't getting paid to do this. It was on his own.
Your Honor, it seems harsh to say that the school was not sponsoring this speech, seeing as how they awarded the teacher for doing such a good job in running these tutoring centers and gave him public acclaim for continuing to keep these tutoring centers ongoing.
But they weren't paying him, were they?
No, Your Honor, they were not paying him.
And this tutoring wasn't happening on school grounds, was it?
No, Your Honor, this tutoring was taking place outside of school grounds, but that does not mean that it had any less jurisdiction. In the Kowalski case, the courts found that speech that bears a sufficient nexus to the school can be censored.
Well, let's change it a little bit. What about instead of a tutoring program, he was going to a Taekwondo class, and the school handed out an award for encouraging exercise and physical education? Would that also be a enough of a sufficient nexus that the school would have jurisdiction to intervene?
Your Honor, please rephrase your question.
Just because, under the facts, he was pursuing math tutoring, but what if he was pursuing something that wasn't educational tutoring? What if it was some kind of sport or outside of activity? Would that still be enough of a nexus for the school to intervene in the conduct?
Your Honor, Hugh Boy's speech at this tutoring center was not the only speech of his that bears a sufficient nexus to the school. Encouraging other students to call him the king of the Einsteins whenever they saw him, whether that be at school or outside of school, also bears a sufficient nexus to school. The current financial state of the sequestered school district was mentioned earlier, but let us not forget why the sequestered school district is being sued. The sequestered school district is being sued for failing to uphold the law. If there is no punishment for running afoul of the law, then what good is the law?
Well, counsel, it seems to me that the principal could be fired, he could have his pay docked. There's all kinds of punishment that could be inflicted on the principal for not doing his job. But that's not what we're being asked to do here. We're asking to give money to the victim.
Your Honor, it seems that monetary damages are necessary in this case, seeing as how the great emotional harm that Tin Wan has gone through could be remedied through tutoring and psychological examining, which cost money. The appellant believes that Tin Wan is not a reasonable student because he attempted suicide. But let us not forget what caused this. Tin Juan's outrageous reaction was fueled by Hugh Boy's bullying. Tin Juan went to great lengths to escape this. He went to the highest levels of authority. He went to the principal, the head of the school, and yet the bullying did not stop. If Tin Juan gone to the highest level of authority and still finding that the bullying had not stopped, gives him little reason to believe that voicing his complaints to any figure of authority would make the bullying stop.
What should or could the school district have done to make the bullying stop?
Your Honor, the school district could have easily punished Hugh Boy for his speech, and it is very likely that that would have resulted in Hugh Boy stopping.
What about my colleague's concern that punishing the defendant in this case, punishing the other student in this case would have encouraged further bullying and made the problem worse?
Your Honor, if that is the case, then it seems that Hugh Boy should be punished further. Hugh Boy should not believe that just because he's been punished, that he needs to increase whatever he was doing that got him punished. That is a failure on the part of Hugh Boy, and this judicial branch should not fear awarding damages simply because of one student.
No, but we do have to worry about whether there's a causal connection. And if it didn't matter what the principal did, this is still going to happen, and there's no connection, right?
Your Honor, in the Kowalski case, when the principal punished the student for her damaging speech, the courts found that this was necessary, and it did stop the damaging speech. Kowalski never once again
And the victim did not get any money, correct?
Your Honor, it is correct that the victim did not receive any monetary awards, but this victim also did not attempt suicide and does not need the same mental counseling. Your Honor, I see that my time is up. I yield my time. Thank you.
Your Honor, I would like to touch up on Mr. Yu and his tutoring site. He was not told to hold the tutoring, and he was not getting paid, and just because he was getting recognition does not mean it was a school event. This is all on his own, out of the kindness of his heart, and it can't be the school's fault for that. That's like saying if Principal Thick hit Tin Juan with his car on the weekend, that the school district should be liable. No, Principal Thick should be liable because he's not on call. Mr. D was not on call, so the school district should not be held liable for that. Hugh Boy lived in the same neighborhood. They all lived in the same neighborhood. So to say that he was waiting outside the tutoring sessions purposely just to taunt Tin Juan is not a reasonable inference, because he may as well have been playing with his friends and come upon the tutoring site and then tease him. It does not state that his full intentions were to go there and harass him.
Why is that relevant? I mean, when he was there, he was harassing him, was he not?
Yes, but that was not his, it does not state that it's his full intentions. He lives in the same neighborhood.
Well, I don't see how it's relevant whether he waited outside on purpose or happened to be walking by accident. The facts are, according to the record, that the harassment did happen, and isn't that enough for us to find that there was a problem?
It could be, Your Honor. And I would like to mention a policy problem. If we award Tin Juan this money, then there will be a huge flood of litigation. Every student that is getting teased will want to take the school to court and get their fair share of money, just like Tin Juan. Tin Juan alone is asking for $80,000. Now multiply that by however many students there are to come, and our school districts are already in a lot of trouble with money.
Counsel, isn't the answer to that for the principal to do his job? If he does his job, there's no lawsuit.
Well, he did do his job. It's just to what extent he did his job. That's what we're arguing. To what extent? Because we know that he did do his job, but whether or not it was good enough or not is the argument. Right, Your Honor?
You tell us.
I believe it is to the extent because he did do his job. He met with Tin Wan, he took down the posters, he did what he saw. He could have. So if we do allow this money, that would be criminalizing Hugh Boy as a bully, and that could follow him throughout, and deeming him a bad child because of mere teasing to Tin Wan is unfair to
I
Hugh
don't
Boy.
think that this lawsuit really concerns Mr. Boyd quite as much. I think what we're really concerned about here is that the principal was notified of a problem situation and did not adequately follow through. And that's the basis for liability, not whatever the young man's future is ahead of him.
Well, Tin Wan's parents, of course they don't think that he did his job adequately because their son attempted suicide. But Tin Wan did have another option. Just because that he was getting pressure from his parents does not mean that he can't go for them for help. That's what parents are for. Therefore, they're there to help. He could have easily talked to his parents.
Didn't the legislature decide that it's the school's job to do something here? And maybe that's because parents don't do enough, but the legislature said that the school is supposed to act, and that's what we're dealing with here.
He did act, though. He did. It may not have been enough for his parents, but he did act. He did do something. It's not like he just sat back and ignored it.
But it's not whether he did something, counsel, it's whether he did enough to meet his duty. And we're trying to find out whether he did. So, is it not a problem that he did not follow up on the incident when he took the posters down? Did he not have a duty to
He did meet with Tin Wan
punish
after
the offenders, to punish Hugh Boy?
It says that it's not our job to decipher how much a principal has to do. They have a right to do something or not. And the statute just says that he has to do something. He has the right to expel or suspend Hugh Boy, but the reasons for why he did not is not the matter, but he did something. He has that right to do that or not. He has the discretion.
So how much is enough? What if he had, so let's say he saw the posters and he said, oh, that's not very nice, and then he walked away. Is that enough?
But he did not do that, Your Honor. But if he had done that, no, that would not have been enough because he blatantly saw teasing and he walked away from it. And in this act, he didn't walk away from it. And because Tin Wan was unreasonable, the principal couldn't have seen that. He couldn't have seen that he would have tried to attempt suicide because his parents and his community were putting pressure on him.
Well, doesn't the statute afford an exception for special needs so that we can take those sort of things into account when considering the needs of each case?
Well, is being sensitive really a special need, though? If he was extra sensitive, then he could have sought more help. Because if the principal doesn't know that he's extra sensitive, then how is he supposed to do something about it?
Well, shouldn't he have investigated more? Doesn't the statute give a school administrator the power and the power to follow through and also the duty to follow through so that they can make sure that they're meeting the needs of every situation and every student so that a one-size-fits-all approach is not enough. You need to tailor your response to the facts and the circumstances of the student and the problem at hand.
Yes, you should do it as a case-by-case situation, and he did follow up. He did not deny Tin Wan. He did meet those standards as they came up. So I'm asking you to find that he did do his job and he should not be held liable for the damages.